Debt relief in Canada, bankruptcy court salutes Canadian military veteran. I recently read a decision of the Bankruptcy Registrar of the Supreme Court of Nova Scotia in bankruptcy and insolvency that really inspired me. It got me thinking about the sacrifices our men and women in the military make for all Canadians, and sometimes they need our help for debt relief in Canada. The decision, in this case, was released August 31, 2018. The first two paragraphs of the Registrar's decision, I found especially poignant. 1. This court routinely considers situations in which the bankrupt is indebted to the people of Canada, through tax or other liabilities to the state. As a matter of general policy, these obligations have a higher moral and sometimes legal priority than to private creditors, as they are borne by all of us, as citizens and fellows of society, and because the public generally must bear the share not paid by someone else. The collective public is an involuntary creditor in the result. 2. What, then, is the situation when that is reversed, when it is the people of Canada who are indebted to the individual? Should compensation paid out as a consequence be considered divisible among creditors in an insolvency? Master Corporal Dirtle was a career soldier. He spent 24 years in the military. He suffers from a post-traumatic stress disorder. He remains under professional care. On November 13, 2013, Master Corporal Dirtle filed an assignment in bankruptcy. This is his second bankruptcy. The purpose of the court hearing was for the court to consider what form of bankruptcy discharge he should be entitled to. There were minimal non-exempt assets and unsecured creditors totaling $73,476. In 2014, while an undischarged bankrupt, Master Corporal Dirtle received taxable income, including $16,778 from a wage loss replacement plan, a rehiring allowance of $28,107.04, including $19,675 in severance pay, pension income of $23,594.10, disability income of $49,289, and $3,624 in employment income. The decision the court had to make was, how much if any of this 2014 taxable income should be considered surplus income. The registrar made a point of saying, "I wish to be clear that nothing should be taken as putting military debtors on a different footing than a civilian. The rule of law, including that of civil contract, is one of the core values we hold as Canadians, and which is protected by our men and women in uniform. What is, however, on a different footing is the debt we owe those men and women when they are injured or ill in the discharge of those duties." The registrar went through a very thoughtful analysis of the law. 1. The wage loss replacement plan. Wrongful termination awards would normally be included in total income, as would pay in lieu of notice. The registrar, however, went on to comment that in this case, the wage loss replacement plan was not termination pay or pay in lieu of notice but rather, pay because Master Corporal Dirtle's PTSD prevented him to continue serving. The registrar concluded that this amount should not be considered as surplus income. 2. The rehiring allowance. The registrar applied the same logic in deciding that this payment should not be included in the calculation of surplus income. 3. Pension income. The registrar could not determine whether this income was solely a benefit due to Master Corporal Dirtle's PTSD or not. However, it did factor into the registrar's ruling. 4. Disability income. The registrar considered this income in light of previous court decisions involving lump sum awards, especially under a workers' compensation plan. The registrar went on to review the actual federal statute under which the payment was made to him. The registrar concluded that this amount would not be included in the calculation of surplus income. 5. Employment income. The registrar concluded that this amount is included in the surplus income calculation. The registrar concluded that if he includes the pension income and of course the employment income, less statutory deductions, Master Corporal Dirtle's income, which must be considered for surplus income, falls under the Superintendent of Bankruptcy threshold for 2014. Accordingly, Master Corporal Dirtle had no surplus income to pay. Since this was Master Corporal Dirtle's second bankruptcy, he was not entitled to an absolute discharge. The registrar did not impose any conditions on his discharge, but suspended his discharge for 1 day. The registrar was obviously moved by Master Corporal Dirtle's service to Canada and of his current plight brought on by service-related PTSD. If you have financial difficulties, you need to seek professional advice from a firm that will show you the understanding and kindness you deserve. The Ira Smith Trustee Team has seen many cases of personal and corporate financial distress. We understand your pain and we know how to alleviate it, with understanding and kindness. You're just one call away from taking the necessary actions to get your debt settlement and back on the road to leading a healthy and stress-free life. Contact the Ira Smith team today.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now.
Oh.